A woman accused of starving her 5-year-old daughter to death out in Indiana finally went to trial this week. But it all came to a screeching halt thanks to a juror. What does this mean? What does this mean for the case? What does this mean for the attorneys who spent all this time prepping? And what does it mean for the defendant who currently remains behind bars? We're bringing on a local criminal defense attorney to sort it all out. Welcome to Sidebar, presented by Law&Crime. I'm Jesse Weber. By the way, as you're watching this and you're into content creation or you're putting things out on social media, you might be wondering, how do we get all these clips out there so quickly? Well, we use something called Opus Clip. Opus Clip is an all-in-one AI editor that makes it so easy to cut, create, and upload videos across any platform. Through AI, Opus Clip generates B-roll, it reframes footage, and it even cleans up audio. It's really easy. You just visit opus.pro/sidebar. You sign up, you upload. In minutes, you'll have perfectly edited clips ready to go. For TikTok, Shorts, Reels, Opus Clip is really your one-stop shop, and having a tool like Opus Clip means that our producers can get you viral courtroom updates instantly. This is the most powerful tool there is to share ideas and edit like a pro. So go to opus.pro/sidebar to get a free week and then 50% off. When 5-year-old Kinsleigh Welty died in April 2024, she weighed a shocking 21 pounds. According to investigators, this little girl was consistently locked in a feces-filled closet inside a trailer home and starved. Her mother, Toni McClure, grandmother, Tammy Halsley, McClure's live-in boyfriend, Ryan Smith, they all face charges related to this little girl's death. Smith, Halsley, they both took plea deals for neglect resulting in death, got 20-year prison sentences, and they were expected to testify against McClure at her murder trial, which, by the way, started Monday, June 22nd, out in Indianapolis. To give you a sense of what had been happening in this trial, so media outlet WTHR reported on the prosecution's just brutal, really brutal opening statement. Anne Frangos, a Marion County deputy prosecutor, reportedly told jurors, quote, "She was killed by the systematic, prolonged, and fatal abuse at the hands of her mother, the defendant. She was subjected to deliberate starvation, deliberate confinement, to physical abuse, to psychological abuse." Prosecutor continued, "I am sorry for what you're about to see and to hear, but it is important evidence. It is important evidence so that you know that she intentionally killed Kinsleigh in the slowest, most painful, and torturous way, and she is absolutely guilty of the intentional murder of her daughter." By the way, little side note, yeah, these are some of the toughest cases for jurors to sit on. It's one thing to sit on a homicide case, but when the victim is this young, when you talk about the allegations, how she died, it's like the worst. Now, in addition to murder, McClure was also charged with criminal confinement resulting in serious bodily injury and battery on a person younger than 14 years old. So the state wants McClure to be locked up for the rest of her life, no chance of parole. McClure's defense attorney, Deanna Martin, different story, reportedly admitted during her opening statement that McClure is, quote, "a terrible mother." This is according to WTHR. A high school dropout, had 6 children with 4 different men. But her argument was McClure did not intentionally kill Kinsleigh. So per outlet WISH-TV, Martin told the jury, quote, "A lot of what Toni does is directly correlated with the way she was raised and Tammy's influence. That doesn't excuse what Toni did. What you will have to decide, though, is did Toni do the crimes that she's actually charged with?" During that first day of trial, the Indianapolis Star reports that a detective with the Indianapolis Metropolitan Police Department cried on the stand. This was when describing the back bedroom closet where Kinsleigh was locked up. The forensic pathologist who supervised Kinsleigh's autopsy also testified, describing the 5-year-old's body as shocking, extremely thin, severely malnourished, and covered with lice. Courtroom observers say that disturbing photos showed that Kinsleigh was quite literally just skin and bones. When she arrived at the hospital, she had feces in her hair, feces stains on the bottom of her feet. She was missing teeth. There was apparently no sign that she had permanent teeth coming in at all. Kinsleigh's cause of death was determined to be complications from malnutrition and dehydration, and the manner of death was ruled a homicide. Now, testimony continued on Tuesday, but you know what the problem was? It's what happened after lunch. Shocking announcement. The judge declared a mistrial. Case is over for now. The judge had dismissed a juror, and the defense argued that the other jurors hadn't followed the court's instructions. So the judge declared a mistrial, dismissed everyone. WTHR reports that the juror apparently had an inappropriate conversation with a witness outside the courtroom, something that is strictly forbidden. It's also now being reported that the Marion County Prosecutor's Office charged that allegedly offending juror with indirect contempt of court, which is classified as a non-criminal charge. Prosecutor Ryan Mears shared a statement saying it is profoundly disappointing that this trial has ended in a mistrial because of inappropriate communications between a juror and a witness. The outcome derails months of preparations by the parties and delays justice for Kinsleigh and her loved ones. We remain committed to presenting this case again and securing the justice she deserves. WTHR also reports that the juror has a court hearing in connection with the contempt charge that's set for July 18th. McClure's trial has now been rescheduled for August 24th, when everything is going to start over. They'll pick a new jury. They'll have to redeliver opening statements. Those witnesses are going to have to get up there, have to testify again. How difficult is that going to be? Okay, so to help me sort through all this, I want to welcome back on Indiana criminal defense attorney Andrew Baldwin. Andrew, so good to see you. Thanks for taking the time. We actually discussed this case, I think it was last fall. That was when Kinsleigh's biological grandfather, right, Brian Welty, filed this lawsuit against DCS, which we'll talk about. But I got to say, I mean, this is a big development. A juror accused of talking to a witness. I ask this question a lot on Sidebar because we always cover kind of like outlier cases. I've heard of jurors speaking to other jurors, and that could be a problem. But a juror speaking to a witness? Have you seen something like this?
In 32 years, I have not seen that. And I practice in that very courthouse where this happened. So that makes it even more surprising if you know the layout of the courthouse, because the jurors are shuttled away into these back rooms that, you know, we lawyers don't have access to those rooms. So the only way that this, I think, could have conceivably happened was at the end of the day when the jurors were released, that this particular juror ran into, on his way to his car or whatever, the juror ran into this witness that had apparently testified. So no,
or the bathroom. The bathroom. I feel like the bathroom, something can happen.
It could be, but the jurors have their own bathrooms and stuff in the back, in these back halls that we even lawyers don't have access to. So I'm not really sure what happened, what the breakdown was, if there was one. You don't hold these jurors all overnight. You know, they have to leave at some point in time.
Yeah. And a charge too, right? Getting charged. Indirect contempt of court. What does that mean?
Well, direct contempt of court is when this particular judge, Judge Snyder, very good judge, very experienced judge, when you tell him to go to hell or, you know, make disparaging remarks about him in front of him.
Not advisable. Don't do it. Yeah, not advisable.
Not a good idea. Indirect contempt is things that happen away from the courtroom. So if you are ordered, for example, I've seen this happen before, where witnesses in a trial are not to be talking to one another while the trial is happening. It's called a separation of witnesses order. And I've had situations where witnesses did talk to one another while the case was pending. We found out about it and we asked for indirect contempt. And that's what happened here. Is there was an order, jurors don't talk to anybody. That's something that the judge tells them. The judge told these these jurors not to talk to witnesses, and he did. And now he's suffering for it.
What do you get for that indirect contempt of court?
Well, you could theoretically, it's kind of a quasi civil, potentially criminal. The civil side of it, that costs a lot of money to redo a trial. And so every day those jurors are getting, I think it's $50 or $60 a day, plus all the initial jurors during jury selection. It might be 10, 15, 20 grand. And the judge could say, you cost the taxpayers all this money. You owe that money. That's your sanction. Yeah. If the judge finds out that it's a little bit more deceivious or something more, wrong about, if the guy walks in with an attitude and says, hey, I'm a juror, you can't touch me, then the judge can say, that's fine, you go to jail for 30 days or something like that.
Was it the right call to declare a mistrial?
Oh, absolutely. On something this serious, you do not need that issue hanging over your head at the Court of Appeals level. You just got to do it. And the main reason is it's not fair to the defendant, potentially. It may not be fair to the state, depending on what the conversation was between the witness and the juror.
Fair, fair. Kinsleigh's grandfather spoke with WISH-TV after this mistrial announcement, and he is worried this could have unintended consequences down the line. Quote, "This has been a grueling process, but I would much rather have this come out now, so not to be part of an appeal or something even further down the road in this trial. The judge gave them and everyone very strict guidelines on this behavior and repeated multiple times throughout the trial. I feel sickened that someone would be so reckless doing something that could potentially have a huge impact on the outcome of this trial." And by the way, Andrew, that goes to a bigger point, right? I say this all the time in the cases where people, look, every criminal defendant is innocent unless proven guilty. But in those cases where you're like, this evidence is overwhelming, they're definitely going to be convicted. I'm not saying it's the case here, but the evidence is strong. You got to make sure that the defendant is entitled to every right and is given every opportunity and dot every I and cross every T. Because what would happen? Imagine like Koberger, right, went to trial and something happened, and then all that goes on, and then down the road, his conviction's overturned and they got to retry. I mean, look at the Eitan Petz case, right? I mean, like that's because you could have a situation where if this happens years and years down the line, and then the prosecution's in a worse place trying to re-prosecute this case, and they might not be successful, and somebody who committed a crime could get off.
Yeah. Yeah, in this case, I think the retrial date is in August, but everything you just said is totally accurate. If it goes to the Court of Appeals and years down the road, key witnesses die, or they move to Hawaii or whatever, and all of a sudden the prosecution is scrambling to assemble a case that was ready, locked and loaded to go back in the original trial date. And the only like what I would say, Jesse, that one of the fallouts from even a short continuance is this. These are experienced lawyers. I've tried murder case against one of these prosecutors. The public defender is like, these are the top of the top. And so they got basically a rehearsal, a dress rehearsal of the trial. So they're going to be able to go back, reconfigure their case, what was working, what wasn't working. Maybe the prosecution revealed some evidence or a theory that they were utilizing, or the defense. And so now these people it won't be the same trial the second time around, more than likely. It's going to be tweaked at a very minimum.
Is there an advantage to the defense at all?
Oh, I think so. I mean, I think learning what the prosecution's kind of theories are, their themes, how they're going to try the case, their approach, the number of witnesses that already testified. Now they're on record. Maybe their testimony, these are all state's witnesses because they went first. Maybe these state's witnesses' testimony will differ in trial number 2. I know it's kind of silly saying that when we believe that the evidence looks so overwhelming from what media accounts are, but until you're in that courtroom and you're watching these people in real time testifying, and they've changed their story from this to this over the course of 2 months, that could have impact on a case.
Do you think that this was potentially leading to a conviction? Do you think the evidence looked overwhelming?
Well, I mean, I'm a defense lawyer, so I'm always optimistic that there's a way to win a case, or a way to at least, I think what the defense lawyer on this case was doing, having heard a little bit of her opening statement, was she was conceding many of the counts and saying she's a terrible mom. But she's not guilty of murder. She's just a terrible mom. She didn't know any better.
No intent, just like no skill set to know how to properly raise a child, something along those lines. So whether that murder conviction had any legs at all to be defeated, I don't know. I mean, emotionally, that's going to take its toll on a jury. Emotionally, it's just a terrible thing for everybody to watch. Even defense lawyers get upset looking at that. And look, when you think about the family and even the witnesses who have to go through this again and again and again, in a trial, it's difficult. I mean, it's hard testifying, it's hard hearing this evidence once, but to hear it again is even tougher. But it does make me wonder, have you seen a case before where it's like this? It's not, the victim is not an adult. The victim is a child, care, custody. It seems to me very difficult, unless it was a one-off episode and a freak thing, if you're seeing evidence of prolonged abuse or prolonged neglect. How is that not intent?
Well, I think you might, and I have no idea. Dina Martin is a terrific defense lawyer. She's one of the top dogs over there, and she's won some cases that nobody ever expected her to win. You know, public defenders get a bad name. I'm a private lawyer, but I always say there's some really terrific public defenders out there. She's one of them. And I don't know, so I don't want to say that I know what's going on with that case. I don't. But you're asking how would you win something like that if it's so prolonged over a period of time? And it could go toward the intelligence of the defendant. Like, you know, yeah, for regular people with normal intelligence, you would know that this is not the right way to do it. But if you are of a diminished capacity in terms of intelligence, not that you understand the wrongfulness of your act, that's different. That's more of an insanity defense, what people might call. I'm talking about more of a diminished capacity in terms of intellectual capacity. You might be able to convince a jury, like, this woman just didn't get it. She just didn't know. She thought this was a proper way to discipline, as crazy as that sounds. And she didn't understand when she looked at the child that this child was suffering. You know, I know it sounds crazy, but sometimes you have to.
No, I hear you. I hear you. I want to talk about Brian Welty's lawsuit. So it was originally filed on behalf of Kinsleigh last fall. It named the Indiana Department of Child Services, as well as multiple individual people that were allegedly involved in McClure's DCS case as defendants. Welty had claimed and claims that their inaction allowed his granddaughter to slip through the cracks and ultimately into her grave. Because according to Welty, DCS was well aware that McClure had previously been convicted of felony child neglect in the past, but was allowed to keep raising Kinsleigh and her siblings. And there's been a lot of activity on the civil docket over the last few weeks. The group called State Defendants filed a motion to dismiss the lawsuit. And at first it looked like the judge had agreed because Welty's attorneys hadn't submitted a response by the deadline. But then Welty's attorneys filed their own motion asking for the judge to set aside that order, for at least for now. They showed email proof that counsel on both sides had agreed to a time extension for Welty to respond. They apparently forgot to submit an official request to the court for that extension. The judge agreed to set aside the motion, and that gave Welty's team an opportunity to file the response to the dismissal request. But in that motion, counsel didn't shy away from the horrifying details. It says, quote, "But Kinsleigh was not hidden from the Indiana Department of Child Services. To the contrary, during the 5 months preceding her death, DCS received at least 5 separate reports warning that Kinsleigh was being abused, neglected, and starved. Reporters repeatedly warned that she appeared malnourished, severely underweight, and was not being fed. They reported that she had been struck with a belt, forced to stand facing a wall for hours, treated differently than the other children in the home, and that her hair was falling out. One report specifically alleged that food was intentionally withheld from her by locking cabinets and the refrigerator. Yet, despite these escalating warnings, and despite defendant Toni McClure's well-documented history of substantiated abuse and neglect involving Kinsleigh, including a felony conviction for neglect of a dependent, DCS repeatedly closed report after report as unsubstantiated." And the filing goes on to say, these report closures did not occur in a vacuum. For years, DCS has struggled to recruit and retain sufficient numbers of family case managers, resulting in excessive caseloads. To address those burdens, DCS allegedly implemented an internal policy directing caseworkers to refer 50% of their assessments to the Safe Assessment Closure Team for expedited closure. Although SAFE Act was purportedly created to assist in promptly closing low-risk assessments once child safety had been confirmed, plaintiff alleges DCS instead used the program to rapidly reduce caseload numbers despite serious safety concerns. 3 separate reports concerning Kinsleigh's abuse were disclosed through this expedited process, all without ever laying eyes on Kinsleigh. DCS's misuse of the SAFE Act was an affirmative act that put Kinsleigh in grave danger. Andrew, I go to you. I know that there's always an argument. Look, our goal is to maintain the family. Our goal is not to remove a child or get involved unless we absolutely have to. But if I'm listening to this, and yes, these are allegations, but if I'm listening to this, it feels like it puts the government in a tough spot.
Yeah, I mean, this lawsuit is essentially bringing truth to power. I mean, you're trying to get the government to change the way that it does things. It's bigger than the lawsuit itself in a way. Like, lawsuits are about money. That's how you get compensated. It's money. It doesn't seem as if that is really what is going on in this lawsuit. It is, we want structural change. We want to bring truth and shine a light on problems that have existed for decades in Indiana, in the DCS, or Department of Child Services arena. And these people, by the way, the DCS employees, they are overworked, they are underpaid, there is not enough of them. And I'm not trying to take, but the leadership, that's who this is really going toward, is the leadership who puts these practices in place. And the legislature has looked into this, and they are trying to figure out what they can do about it. But this is a big, big deal.
But to be clear, that's not a legal defense. Like, we don't have the resources to be able to do it. Like, that's not a legal defense, right?
No, I'm not a civil lawyer, but there's no way I think that stands.
Right.
I'm just saying, DCS employees, they get a bad rap too, but
Sure.
They do. But some of them, it's deserved. But really it's the leadership of the department. And that's who's being put on trial in that civil case.
There's an interesting question about qualified immunity. I just want your thoughts. So the defendants have argued that they're protected from litigation. They're insulated from litigation. They can't be sued. The plaintiffs argue that not every single action undertaken by a government agency is automatically protected. Quote, plaintiff does not allege that DCS failed to provide police protection, failed to apprehend a criminal suspect, or failed to prevent crime generally. Rather, plaintiff alleges that DCS failed to perform its own child protection functions after receiving repeated reports that Kinsleigh was being abused, neglected, starved, and malnourished. Andrew, any thoughts on that?
Well, I'm not a civil lawyer, so I
Sure.
don't want to pretend that I am. But, I think there's always, where there's a will, there's a way. There's always some carve out that, and it sounds like that's the carve out there is what you just read. And immunity is, I did do civil work many years ago, and it's always like, oh my gosh, I can't believe we're not able to sue this guy over that. And because they're protected by this immunity clause or whatever. But there was always a potential, at least, if the behavior was so outrageous, so out of the norm, that you could actually overcome and pierce that veil of immunity. And that sounds to me like if this isn't the case for piercing the veil of immunity, I don't know what case exists that would.
Right. Going back to the criminal case, so McClure is expected to be back in an Indianapolis retrial in July or August. We're going to be keeping a careful eye on that. How tough is jury selection going to be now? Because, after everything that just happened.
I think it was already difficult. I mean, this case got a lot of press, but even the facts themselves, even if you don't know about the case, once you as a defense lawyer, you have to get out ahead of what they are about to witness and see. So you got to talk about, you're going to see terrible photographs. Are you able to overcome that? You're going to hear these terrible facts. But now you have another layer of problem. And that is, did anybody hear about the juror that came out and talked to a witness? And now you've got I think jury selection probably got added to maybe at least a few hours, if not a day, just because of the news spotlight on this case. Locally, I can tell you from living in Indianapolis, it is getting a huge amount of press. And the case itself, it got some good press back in the day. That was 2 years ago. Now it's back on the spotlight.
We'll follow it. We'll see what happens. It's a big development. Andrew, thanks for taking the time.
Thank you, Jesse. Good to see you.
And that's all we have for you right now here on Sidebar. Everybody, thank you so much for joining us. And as always, please subscribe on YouTube, Apple Podcasts, Spotify, wherever you should get your podcasts. You can also check us out on NBC's Peacock as well. If you want to follow me, X, Instagram, my News Nation show, Jesse Weber Live, Monday through Friday, 11 p.m. Eastern. See you next time, everybody.